All right, so let's take it away. I'm throwing the 60-second time clock up on the board. So that's going. So simple thing is people are mistaken. They think that sometimes that there's an obligation, there's a duty that when you're doing doing something wrong, that the other side has to send you a cease and desist letter. They have to give you a chance to rectify it, or they can't pursue you in court. This just simply not true. If somebody wants to, if you're doing something wrong, so let's say you're infringing a trademark or a patent, or you're violating an agreement or doing something else that's legally incorrect, they don't have to wait 90 or for 90 days, or they don't have to wait for a period of time for you to rectify it. They don't have to send you a cease and desist letter. One day, they can just file a lawsuit. You'll get served from the court, and then you'll have to work to rectify it and pay damages. So you don't have to give anybody legal notice. You don't have to send a cease and desist letter, and they don't have to give you a chance to fix what you've done. So that's the simple answer. You don't rely on receiving a cease and desist letter because they don't have to send it to you. So that's kind of the 60-second answer. So now I'm going to throw the 5 minute time clock up, and we'll expand on that just a little bit. So now if you were to expand on that, so you're saying, okay, well, they don't have to. Why do most people send a cease and desist letter? Well, most of the time, it's because if you were to look at it, lawsuits are expensive. Neither side wants to spend years battling. They don't want to spend, tens to hundreds to millions of dollars, depending on the type of lawsuit, the size of the company, and how big the battle is, in order to rectify an issue, especially if it's something that may be more minor, maybe more negligible. A lot of times they will send you a cease and desist letter. Couple things to note. Just because they send you a cease and desist letter doesn't mean that you may not have to still pay compensation or damages. They may give you a heads up, and in the cease and desist letter, they'll say, hey, go fix this. Go take down your trademark issue, or you need to rectify the breach of agreement or the breach of contract. After you do that, you may still have to pay damages. They may say, if you don't want to see a lawsuit, we've already incurred damages. You've hurt our brand. You've made us lose money. We've otherwise been harmed. And in order to fix this, you now have to go and pay X amount of money in order to not go to court for us to not see those damages. So even if you receive a cease and desist letter, it doesn't simply mean you'll fix it and it'll go away. Now, sometimes they will, because they'll look at it and say, hey, we're a smaller company or even a medium-sized company. We don't want to be aggressive. We don't want to be, feel like we're a bad actor. So people will go and they'll simply rectify the issue. That may be good enough, especially if you're kind and you're nice and they figure you're a small business or a small company. They may just say, hey, it's not, while we could do something here, it's not worth it. That said, they're going to do the calculation. One, they're going to look at it and say, how big of a company are you? Can you actually, have they damaged you? In other words, if you violated their trademark, you infringed on it, have you made money? Have you profited from using their trademark? Or vice versa, have you damaged their brand and confused people and made them lose sales or made them lose money? They're going to look at that and into that calculation. And if that calculation is large enough, they'll either say, hey, you have to pay us money, or they may simply say, you're too small. You probably aren't going to have much money to pay for. You've only been out a few months. We're not going to make you pay. So it is a calculation. How much have you damaged them, or how much money have you made from them? Are you likely to be able to pay? And what is the recourse if you don't pay or if you don't do anything? Then they're going to look at that and say, okay, those are the calculations. Do we think we can make damages? Not. A lot of times, if they're good actors, they'll send a cease and desist letter. They will give you a chance to fix the issue, and you may have to pay some compensation, and you may ignore it. The other thing to think about with the cease and desist letter, 99 times out of 100, if you send it as an individual, if I'm on the other side or most attorneys are on the other side, they're just going to throw it away. They're going to say, hey, if you can't even afford an attorney, you can't have a law firm or prepare this or otherwise afford a law firm to represent you, very low likelihood that you're going to actually pursue anything further. You don't have the funds, you don't have the money, and we're just going to wait and see if you do anything and what happens. And until you actually get more serious about it, it's not worth the time or the hassle in order to even worry about it. So if you're on either side, if you receive a cease and desist letter, if I don't get too tongue-tied, and it's from another individual, most of the time you just ignore it and see if they do anything further. If they get more serious, most law firms are going to say, hey, before we spend, unless they just want to run up the bill, unless they're just a big firm and they just want to get a whole bunch of money from a large client, most of the time they're going to say, hey, why don't we do a cease and desist letter, make it more formal, come from a law firm and see if we fix that. And so, if a lot of times if you're on the one side, if you ignore it from the individual, if they are serious, you'll get a follow-up from the law firm. Again, you don't have to, but they large times will, and vice versa. If you send it yourself, you got to realize that's an indication they'll probably just ignore you. So that's kind of the takeaway. One is you don't have, neither side has to send a cease and desist letter. They don't have to give you notice. They can simply file a lawsuit, say there's damages, go after you, and now you're tied up in court, and you can't simply just fix it you can't go to the court and say, well, we took it down off our website or we fixed it, so it's gone away. You've already incurred damages. And so simply relying on the fact that a lot of times people send cease and desist letters or demand letters, don't rely on that. Don't go into something saying, I'll just do whatever I want. If there is an issue, they'll give me a heads up and I'll just fix it at that point. No harm, no foul, because that's oftentimes a erroneous assumption and it will cost you a lot of money. Sometimes it's correct, most of the time it's not, but don't rely on that. In the meantime, plan accordingly that if you do go down that route, you'll want to have a good amount of money set aside if they do come after you. So that's the 5-minute answer and the 1-minute answer. If you do have any other legal questions, reach out to us here at Miller IP Law. We're happy to help. And in the meantime, best of luck with